reading the notice and coming here to spend some time with us today. We've missed all of you, and we've been thinking for quite a while about trying to do an in-person CLE because it really helps to see people, talk to people, see what people do in court. It's all a really good teaching experience and learning experience. So we're really excited that you're here today. In the good news, Julie and Anya won the awesome book. And in the maybe less so awesome news, but necessary news and something that the judges have talked a lot about over a long period of time, we are going to go back to being in person for some of the reasons that I just mentioned, which is mentoring, learning, teaching, being here is important. We are looking at sometime after Labor Day, so we're not going to tell you have to show up tomorrow and from then on, but we hope that'll give you all time to plan logistically and also solicit from the bench and bar any suggestions on logistical types of things, but that is what we plan to do going forward. We're really aware of the efficiencies of what we've been doing, but over the course of time we just feel that it doesn't bear out against what we've lost as a bar, as a community, as mentors for young lawyers. So with that, I'm going to turn the program over to Karen Visser, and thank you for all your hard work on the program, Karen. And again, we really appreciate you all being here. I know the program's going to be great.
Thank you. I'll echo what Judge Ellis Monroe said, and thank you for trekking out in the rain, if it's still raining. And I wanted to just thank a few folks, our co-sponsors of our program today, the Atlanta Bar Association Bankruptcy Section, and the W. Homer Drake Jr. Bankruptcy American Inn of Court for providing funds for our lunch today. I also want to thank Ms. Vania Allen, the clerk, and her staff for helping us set up all of the room and bringing tablecloths and everything that they did for us. Also, IT for their technical support today and for recording this program. It will be available on our website along with all the other past programs. This is the 14th installment of the Bench and Bar Lunch and Learn series. So there's a wealth of information available on the website if you want to go back and look at past videos and materials. So, and thank you, of course, to our judges for supporting us today and for encouraging you all to come back to court in person. And for our speakers today, thank you so much for accepting the invitation as well. We have, of course, Judge Paul Bonnefel and Tamara Ogier and Carrie Oxendine and Ed Sevier. Judge Bonnefel has been a bankruptcy judge since 2002. Prior to that, he was a member of what was then Lambert, Bonnefel, Cifelli, and Stokes, PA, where he represented debtors, trustees, and creditors in commercial matters, and he served as a Chapter 7 panel trustee. He is a graduate of the University of Georgia School of Law and Florida State University, a fellow of the American College of Bankruptcy, and a recipient of the Pollard Award. He's the co-author of the preeminent bankruptcy Chapter 13 book. And he's also the author of the most cited to guide for Subchapter V on the internet.
5.
Sorry, 5. Let's see. He has taught law school classes at Mercer for many years, and he has mentored countless interns and a few law clerks, including me. Thank you, Judge Bonnefel, for that. Tamara Ogier is a partner with Ogier, Rosenfeld, and Style PC. She's a member of the panel of Chapter 7 trustees for the Northern District of Georgia, and she is a Subchapter 5 trustee. She has been practicing law in the area of bankruptcy and creditors' rights since 1995, and she's active in numerous professional organizations, and has held leadership positions with the National Association of Bankruptcy Trustees, the State Bar of Georgia Bankruptcy Section, and the Atlanta Bar Association Bankruptcy Section. And then we have Carrie Oxendine. They sat in a different order than I had them. Carrie is a bankruptcy and consumer rights attorney representing debtors in bankruptcy cases under Chapter 7 and 13. She earned her JD from University of Florida Levine School of Law and her BA from the University of Central Florida. She started her legal career with Clark & Washington in 2004 and then moved to Berry and Associates in 2006, where she's been since. Ms. Oxendine has served on the board of directors of the SBLI since 2016 and was a 2022 recipient of the Lewis C. Brown Jr. Award. And finally, we have Ed Saphir, who is a standing Chapter 13 trustee for the Northern District of Georgia and has worked in the Chapter 13 trustee's office since 1999. Prior to that, he represented consumer debtors. He received his BA from the University of Georgia in 1993 and his JD from the University of Georgia in 1996. So, thank you all for being here, and take it away. Thank you.
Next slide. Next slide. All right. First of all, I'm Tamara Ogier. I want to start by saying, if you didn't notice, the title of this was Back to Basics, Bankruptcy Fundamentals for New and Younger Lawyers. I recognize way too many of you for that today, but we're happy to see all of you again. This is going to be really very basic for most of you. It is a bankruptcy at a 500-foot level. So this is, what did you call it? Singing to the choir, which is an oxymoron. But so we're going to start with the fundamentals of bankruptcy, and this is really fundamental. One of the basic principles that overlay everything that we do and how the code is interpreted. There are several different principles that we look at. Equity of distribution being probably the most important. Unless you're categorized as a priority debt or you're subordinated, the basic premise is that general unsecured creditors should share equally in all distributions from estate assets. That plays into a trustee's ability to recover preferences, in that it's a primary element. You've got to show that they've received more than they would have in a Chapter 7. It impacts the automatic stay because it stops creditors from taking more than their pro rata share of estate property. And it's a confirmation requirement dealing with Chapter 7, 11, 12, and 13 plans that forbid unfair discrimination or inequitable treatment of creditors. So equity of distribution is something that we consider when you read any of the code sections. Another primary principle is the debtor's fresh start. So there's a Supreme Court case that talks about the entire purpose of bankruptcy is to relieve the honest debtor from the weight of oppressive indebtedness and permit him to start afresh, free from the obligations and responsibilities consequent upon business misfortunes. This principle means that oftentimes there's a more liberal reading and interpretation of statutes in favor of a debtor. That would be in exemptions, generally construed in the debtor's favor, in dischargeability exceptions. I can remember Judge Mullins used to call an objection to discharge or dischargeability the nuclear option. It's just the last resort, and the debtors get all sorts of benefit in their favor. It also results in a broad definition of what is a claim and what is property of the estate. Definition of a claim is in 101, and it includes just about anything that the debtor could claim, whether it's fixed, contingent, matured, unmatured, liquidated, undisputed. It's just very, very broad. It's generally any obligation of a debtor that can be said to be existing or sufficiently rooted in the pre-bankruptcy past. It doesn't matter if it's liquidated, disputed. It's just they can discharge just about anything, with certain exceptions, obviously. The property of the estate is also very broadly defined in Section 541. It captures most property interests that a debtor may have. Exclusions are in 541C. It would be where a debtor is holding something in trust for another party. Think of spendthrift trust, an IRA, or bare legal title. And applicable non-bankruptcy law is generally what controls whether or not a debtor has an interest in property. And of course, the filing results in an automatic stay, and that's fundamental to bankruptcy. The stay comes into existence immediately upon the filing, with, again, certain exceptions if there are prior cases. But actions taken in violation of that stay are void regardless of the creditor or the actor's knowledge, and can result in damages if they did it with knowledge. That damages can include attorney's fees and punitive damages under 362K. But for newer and less experienced attorneys, it's really very important to understand what the automatic stay actually prevents and what it doesn't prevent, and when it terminates, and what the creditor can do once the stay is annulled or lifted. It's also important to remember that the stay applies to the debtor too. They cannot exercise control over property of the estate either. That especially applies to a Chapter 7 debtor. They can't go out and sell their house. It's got to run through the trustee at that point and through the court. I think we got to go to the next code now. Next slide. Yeah, okay. So this slide deals with reading the bankruptcy code. Again, it's a fairly intuitive structure, and I actually wondered last night, and I bet Judge Bonnefeld would know, why they only use odd numbers except for Chapter 12. Do you have any idea?
I have no idea.
Yeah, I should say it was.
Apparently that leaves room for growth.
And I guess
Left
Chapter
room-
12 was a growth, yeah.
Left room for Chapter 12. Another thing is the bankruptcy code does not use the word bankrupt. It's not in the bankruptcy.
Did not know that either. All right, so the first three chapters, which are 1, 3, and 5, generally apply in all bankruptcy cases, 7, 11, 12, and 13. But chapters 7, 11, 12, and 13 only apply in cases filed under that chapter unless it's otherwise noted. There are a few exceptions that cross lines there. The best starting point is 101. That's the definition section. It's a great idea to always look there first. You'd be surprised some of the words that are defined. Section 102 contains the rules of construction. That talks about the fact that includes or including is not a limiting term. It includes these things, but could include a whole lot more. For example, 102.1 talks about notice and hearing, where you're required to have a notice and hearing. That doesn't actually require a hearing, but it does require notice and an opportunity to be heard, so that parties can be heard if they want to be. That's how we wind up being able to do negative notice and hearings, which I think are going to be a whole lot more important as we come back to court. And we'll talk more about general orders and things like that as we move forward. Next slide, and I will kick it to Mr. Severe.
Good morning. Thank you. Good afternoon. So in addition to the code, of course, we have the bankruptcy rules. This is the federal rules of bankruptcy procedure. This complements the code, right? This kind of fills in the gaps in the code in terms of how things actually work. And the rules are divided into parts, which kind of makes it easier to look and find what you're looking for. So parts 1 through 4 generally deal with administrative matters. Part 5 deals with the duty of the court and the clerk's office. Part 6 is then the trustee's collection and liquidation of the estate. 7 then deals with adversary proceedings, and Part 9 goes to general provisions such as how do you compute deadlines and dates and things of that sort. The definitions and rules of construction in section 101 and 102 of the code that Tamara talked about also apply to the rules, so it's important to keep that in mind. The rules also, though, contain their own definitions in Rule 9001 and their own rules of construction in 1001, so it's important to keep that in mind as well. One thing to note is that the rules change fairly often. You know, the code stays the same because it requires Congress to act, which doesn't often happen, but the rules are changed by professionals, who work and actually get things done. So the rules do tend to change, and we one of the things cited on the slide is that there was a restyling project that took effect in December of last year, December of 2024, which kind of clarified some of the language in the rules, but also did change some of the numbers. So it's important to look at that and make sure that if you're using forms or templates, that those match the currently restyled rules, because it's easy to fall into a rut with those and not keep them up to date. As I mentioned, the rules do change. We have right now rule changes pending with Rule 3002.1 and 8006. Those will go into effect in December of this year, December 2025. And I would note that we are fortunate that one of our colleagues, Nancy Whaley, is on the bankruptcy rules, the advisory committee on the bankruptcy rules. So we have a voice there for that project. But it's important to keep track of the rules. I mean, our court does a very good job of sending out notices of changes in the rules, but it's important to keep track of that. And again, make sure your forms are up to date on those matters, and also to be sure that you just keep up with what's in those rules and what the changes are. We can go to the next slide as well. So in addition to the rules, it's important to remember that the federal rules of evidence also still apply in bankruptcy cases. For us consumer lawyers, we try to avoid evidence, but every now and again you're going to have to deal with it. So it's important to brush up on the rules of evidence to make sure that you're following them. It's also important to note that we have local rules. The Bankruptcy Rule 9029 allows local courts to adopt their own procedural rules as long as they don't abridge, enlarge, or modify any substantive rights. So no local rule can trump the code or the bankruptcy rules, but they, again, sort of fill in the gaps to actually make practice and procedure possible. We also have general orders, and these are all available on the court's website, of course. And the general orders, again, tend to deal with a lot of administrative issues. So in Chapter 13, for instance, we have a general order that deals with the Chapter 13 plan. We've adopted a form plan in our district. The general order deals with how that plan is to be administered, how amendments to the plan are to be filed, hearings on modified plans, etc. And we also have, of course, a bankruptcy a general order on compensation of debtors, attorneys in Chapter 13. So it's important to review that as well, because it does set forth how that procedure works and how that works. In addition to knowing the general orders and the local rules, it's important to know your judge, right? They always say know the law, but also know the judge. All of our judges have web pages on the court's website, and it's important to go look there and see if they have any specific procedures, say for adversary proceedings, evidentiary matters, things like that, to make sure you're in compliance with that. You can research Northern District of Bankruptcy opinions on the court's website. There's a link to that on our court's website. For cases since 2017, they're provided by the Government Publishing Office, and they're at no cost. And then cases that were issued or opinions that were issued between January of 2004 and December of 2016 are also listed on the court's website itself, and they're older opinions. And it's important to note that a lot of these are not published. They're not on Westlaw or not on Lexis, which can be very useful to gaining insight into local practice and procedures. In addition to those resources, I would mention Judge Bonnefell's book, which was raffled today. That's the treatise that he's co-authored with the late Judge Drake and Adam Goodman, who was former Chapter 13 trustee here in Atlanta, but now is in Colorado and Wyoming. It's a great book, a lot of information in there. There are other resources, of course. And Carol Collier-Smith mentioned to me that today that NACBA, the National Association of Consumer Bankruptcy Attorneys, has started a mentorship program starting this week, I believe. And so that, is something to look into as well if you're looking for mentorship from that organization. From that, I'll turn it over to Carrie.
Okay, so success begins, with your good client intake. So our job as debtors attorneys during our initial consultation, the intake is to absorb all of this information that our clients, the debtors, have been living with and dealing with, and that they're trying to get assistance with. You have to absorb all of that information and then make a plan with a case that's going to be beneficial to them. What they want, what your client wants, what the debtor needs, and then what we can actually do are all things that you need to be able to gain from that initial consultation. Of course, you need to determine your client's objective and what they're sitting in front of you for. Are they just looking for a discharge? Are they about to lose their car? Are they trying to save their house? And in our practice, in our firm, we have over the years made our consultation intake questionnaires help in that process. And obviously everybody is going to do their intake differently and everybody wants different information. And as you practice longer, you're going to change those forms, you're going to create your own forms, but all of these help you get your client the best result for the bankruptcy that they are there to, the help that they're trying to get from you. Checklists are imperative in our world. Make sure that you're getting all the documents that you need, make sure that you're getting what they want you to know so that you can get them into the case that they need to be in. The questionnaire and the document checklist get the basic information, and in my opinion, tailoring those to how you speak with your client and how you need, what information you find helpful to help you get them into that case is very helpful. The next thing is making sure that your questions and your language is understandable to the non-lawyer, the debtor sitting in front of you. Know who your audience is. They are in front of you because they're usually in a horrible position, the worst time of their life, and it's not always easy for them to get that information out to you, where the questionnaires and the checklists can help you in that situation. The other big thing is to stress to your client the importance of disclosure. You have to get them to see that they need to help you help them. A lot of times they feel as though giving you information is going to hurt them, and you definitely don't want to find out once the case is filed that, you know, there's a Van Gogh painting that the aunt is holding for them in Florida. So make sure that you're expressing to them that you can't fix what you don't know about. And if the more information that you're able to get from them, the better that you're going to be able to help them. Full and accurate disclosure, obviously, is what we're talking about. And a lot of times if you don't get that information, denial of a discharge is something that your client needs to be aware of. And then, of course, worst of the worst would be a criminal prosecution. So it's very important that you make sure that you are getting as much information disclosed as possible. View the client's answers with a critical eye. This is basically fact-checking. It's a delicate line that you are walking when you're building this relationship with your client, and a lot of times you're going to get information from them that is wrong, and you need to be able to use your attorney critical eye at that point to get the information that is consistent, accurate, and get that all into your petition and plan and schedules.
And I would jump in here and say, get all the documents before you file the case. As a trustee, I know you're laughing at me as debtors' attorneys, but how can you file a case without having the tax return in advance? The number of times I get to a 341 and the attorney hasn't even seen the tax return, and then I get it before the reset, and there are businesses, and there's a house, and there's, you know, it's just, it's staggering to me that you could file a case without looking at that document that's going to tell you so much about your client.
Absolutely,
So
100%.
try to get those first.
Make sure that you're back up to the front, your questionnaire and your checklist. Make sure your document checklist has all those documents that you really need to be seeing before you file anything, of course. And definitely tax returns. I can't tell you how many times a client doesn't even know that the person who filed their taxes put a business on their tax return.
Oh, yeah. That happens a lot.
They 100% have no clue that there's a Schedule I. So yes, you need to look at it and you need to know that information. And
trustees make referrals for those, but to be clear, we're not referring the debtor. The IRS or DOJ is actually looking at the filers, because they're filing false tax returns and the client is saying, I didn't tell them I had a business. And they were just trying to get a refund for their client. So you tell your client, you're not in trouble for this. You've got to file an amended return. You're going to wind up owing money, but you're not going to get in trouble for disclosing this.
And that goes back to the frank conversations.
Yes.
It's all about building that relationship with your client and making sure that they understand that you are there to help them, and you can't help them unless you have the accurate information. I'm sorry, go ahead.
Well, I was just going to add with regard to the tax returns, what we see a lot in our Chapter 13 practice is the tax filing status. So married debtors filing, both head of household or both single. Again, it's probably the preparers that are doing this, putting them in there to maximize their refunds, but it's incorrect, probably. So, those we also, as Tamara said, we do refer those to the U.S. trustee. And again, I think what they're looking for, as Tamara said, is not really to go after the debtors, but to look and see if there's patterns with tax preparers who are preparing these returns for people. But again, you want to, as Carrie said, you want to know this on the front end, right? You want to know about this when you go into the case, not later on in the case.
Mm-hmm.
Just as an indication that some things never change, I remember from my early days as a lawyer that somebody, and I'm going to attribute it to Neil Batson, just because Neil would say something like that. And that is, you've got to get the facts, because if you don't get the facts will get you.
That's a good one.
And I know Neil said when he goes into court, he wants to know the facts of that case better than anybody else in the courtroom. Better than anybody else in the courtroom, and he did.
And then the last one I think on here was the your client's identity and competence to proceed. This came into effect a lot in the past 5 years, where a lot of us are doing initial consultations by Zoom and phone calls. You want to make sure that your client, the person that you're talking to, is the person that you've got the ID and the social security card for, that you've got to make sure that you're checking that information. The social security cards are usually an issue. A lot of people, most of the people don't always know where theirs is, so that is something that you want to make sure that's on your checklist, that you've reviewed and checked before you get that case filed. And then your client's competence to proceed. When you're having this initial consultation, when you're talking to them, when you're getting all these facts, you're going to be able to make a determination in your professional opinion as to how they can proceed.
Does the verification of competence apply to a creditor's lawyer representing a mortgage servicer?
Next question.
I'm sorry, McCormick's not here to hear that.
And then this one is continuing on with the client intake, checking for eligibility. Obviously, you want to make sure that your client is eligible, 109A, G, and H. You want to make sure that they are a Georgia resident, they have domicile. The 180-day willful failure to abide by the court order, 109G, we all like to call it, obviously, in the credit counseling. We all use different credit counseling companies, but make sure that you have a relationship with yours, and then that can help you get your client the information that they need to get those done. Most all of ours are done online, but a lot of clients prefer to go in person to do them again now. So make sure that you're using one that the U.S. Trustees website has a list of the approved agencies. And then the other big one that you need to make sure that you're checking is prior cases. Whether or not whether or not a debtor has had any previous cases can determine the path for their current case. So you want to make sure that you've reviewed to see if they've had a previous discharge, and if so, when. Whether or not the automatic stay is going to be applied or limited, and whether or not you need to file a motion to extend the stay or a motion to impose the stay. On that matter, back to the judges, the different judges and their court websites, they all have information on there to make sure that you're able to get you have to file the motion and have a hearing within the 30 days to get the motion to extend. And that goes back to having a relationship with your courtroom clerks to make sure that if a date is not going to fit into that time frame, you're able to get some options available to you. A lot of the judges will allow you to have hold the hearing in a different courtroom if there's not a date available, or to do, they don't like this, but we have in the past had bridge orders would allow you to get a little more time for an available court date. But again, that's knowing your chambers, being able to have an open line of communication with your clerk to know what you can have available for you.
This is sort of back to the basics, and it just occurred to me, and they said I could interrupt. Of course, they would.
We assumed that you would.
BAP CPA was passed in 2005, right?
Yes.
That's 20 years we've been living with 362C, 3 and 4, or whatever those numbers are. I would think that everybody would now know how to do a motion to impose the stay if there have been more than 2 cases, and to extend the stay if there's been 1, and would know how to serve it and who it needs to be served on, and that everybody in this district wants you to look at the previous case and serve the lawyers who appeared in the previous case. And it would seem to me that one could now figure out how to do that. And so I would not, as I routinely get on every Chapter 13 calendar, my staff says, what about this? They didn't serve such and such, or it was filed too late, or they didn't schedule the hearing on time. And so please check your procedures and tell your friends that they need to check their procedures, because it's really annoying after 20 years.
Do not.
Judge Richie Craig agrees with me.
Yes.
That's rare, but
It is very rare.
does Judge Deal agree with me?
And Judge, I think we have
Never. Okay.
a question perhaps in the back, or a comment.
So in the intake process and looking at tax returns, on your comments, I'd like to also say, debtors counsel on intake, ask for divorce decrees and DRFAs in a divorce case. Because I've had a lot of cases where, in one case, Judge Bonifeld, with a divorce decree, the ink isn't dry yet, and they disclose their assets in the divorce decree and their assets on the DRFA, the domestic relations financial affidavit, and debtors counsel isn't disclosing the assets that are in the divorce decree, where the divorce decree is only like a month old or even 6 months old, and the schedules really should show those assets.
Agreed. Yes, make sure you're asking all of those very meaty questions when you're sitting in front of.
And I think, as Carrie indicated, it's very important to make sure your client understands that this stuff will come out. I mean, even if they don't tell you about it, someone will figure it out. It's either going to be Shana coming out, representing the ex-spouse, or it's going to be the Chapter 7 trustee or the Chapter 13 trustee, or a creditor is going to point this out, is going to figure this out. Nothing is hidden anymore. We have access to a lot of information these days, and it's important that your client understand that if they don't tell you, someone else is going to disclose it.
And not just access to it, as trustees, we're getting it fed into our systems.
Yep.
I'm now beta testing a service that will give me the debtor's full background check. So I'm getting their real estate reports, their title report, their vehicle titles, their criminal histories, everything that's publicly available is getting fed into my system, and I'm seeing it before I get to the creditor meeting. So it might be a good idea to go look at that yourselves before you file this case.
Next slide. Bankruptcy and state law. So these are just more a wealth of information that's out there for you that you need to make sure that you're looking at and reviewing and touching base on as you're building your case, as you're building your petition and your plan and your schedules. It's important to understand all the state law remedies for foreclosures and pursuit of the deficiencies. what communications were required to be sent to your client, the timelines for when they were supposed to receive them, when they can be collected on. All of those are relevant to when you want to file your case and how that your client may wish to proceed going forward in a case. Whether or not they're going through a repossession, obviously that kind of changes your timeline all around, and that's a quick, let's do it tomorrow kind of situation, but whether or not there would be repercussions for that is also something that you need to make sure that you're addressing when you're putting the case together. Evictions, that's been a pretty hot topic for the past couple of years. What happens where they are in the eviction process? Has the writ been filed? Are they just getting letters? Like, all of those things are part of your consultation and what you really need to be able to have the timeline of when you're advising your client on whether or not the bankruptcy is going to help them in the eviction process. Obviously, the stay is going to be in place and it's going to stop everything immediately, but what does that mean for your client? Are they going to be able to stay in the property for the next 30 days? A lot of times you see in the leasing contracts, they're kicked to a month, and if they're now month to month, there's no way for you to fix that $6,000 deficiency in a Chapter 13 plan before the term ends, because it's ending tomorrow. So all those things you need to look at and make your timeline of when you can file, and make sure that your client understands what they're actually going to be able to achieve with the case. The judgments and garnishments, same thing. You want to make sure that they understand how fast you're going to be able to get their money into their check. A lot of clients think that they can file today and their check that has already been processed by payroll 2 weeks ago is not going to get hit tomorrow. So making sure that they are aware of the help that you're actually going to be giving them and the timeline of filing the case, excuse me, should be all part of your initial consultation. The next slide is the pre-bankruptcy considerations. Back to just getting the whole big picture from your client of what you're going to be able, your potential client, of what you're going to be able to do for them and the timeline of when they're going to be able to do it. When they're seeking legal advice from you, there's a lot of things that you need to consider, including some non-bankruptcy alternatives. If they, depending on where they are in the timeline of the garnishment, maybe you can assist them without filing a bankruptcy. A lot of times some calls and communications with the creditors can help, and so you just want to make sure that you've considered any non-bankruptcy alternative. You want to make sure that they understand what's going to happen if they don't file, obviously, and what benefits will be available when they do file. So just keep the big picture in mind as you're doing the consultation. And if you are thinking about it as a timeline, think about the case as a timeline, think about it as a package, and you're building it from the ground up, then that helps you get the best possible advocacy for your client. And then that gets you to where you're going to decide about Chapter 7 or Chapter 13.
All right, so yes, just deciding between Chapter 7 and 13. So even as a Chapter 13 trustee, I'm going to admit that Chapter 7 is probably the better option if a debtor can do it. It's going to be faster. It's going to be cheaper. But that's a big but. If it's going to work for them. So there are plenty of reasons why a Chapter 13 might be preferable. Number one would be if in a Chapter 7 case, the debtor would be subject to dismissal for abuse. So this is basically, they failed the means test, so to speak. They have too much income relative to what's allowed under the means test, and the U.S. trustee or Chapter 7 trustee or party could bring an action to have the case dismissed for abuse. The second case would be if they're not eligible for a Chapter 7 discharge. So under the code, of course, the discharges are measured from filing to filing. So if a debtor had a Chapter 7 discharge, they're ineligible for another Chapter 7 discharge for 8 years. It's a long time. So if the debtor's had a previous Chapter 7 discharge within that 8 years, probably another Chapter 7 case is not going to do them much good. but they may be able to file Chapter 13 because ineligibility for discharge doesn't mean ineligibility to file. Right, a Chapter 13 can be filed even though the debtor is not eligible for a discharge, and it may give them some benefits in terms of reorganizing some of their debt, keeping a car, keeping a house, at least in the interim, things like that. But I think it's very important that the debtor understands the risks of that, because where there is no discharge at the end, for instance, on a car, I know there was a case recently, a Chapter 13 case in our district where the debtor was ineligible for discharge in a Chapter 13, completed the plan. The plan provided for what they thought was full payment of the car claim under contract interest. The payments were applied by the lender contractually. And when the debtor got to the end of the Chapter 13 case, after paying, I think, over $20,000, maybe even closer to $30,000 to this creditor, they still owed $11,000 contractually, just because of the way payments were being applied, the way interest was being calculated. And this is where the plan provided for that claim to be paid in full and to be paid with contract interest. So it's very important that the debtor understands that at the end of that Chapter 13 case, they may not get clean title to that car. They may not, they may not they will not have discharged anything, obviously, but they'll just getting the benefit of that automatic stay for those 3, 4, 5 years, whatever that Chapter 13 case lasted. But again, that, weighing everything, that may be in the debtor's interest to deal with the problem they have at hand right at the outset. Keeping non-exempt property. So these days, everybody seems to have equity in their real property. So that makes Chapter 7 less attractive, because if you file Chapter 7, Tamara or another Chapter 7 trustee is going to sell that house, right, to pay creditors. So that makes Chapter 13 more attractive. Of course, then the debtor has to meet the liquidation test, which is they have to pay into the Chapter 13 case at least what the creditors would get in the hypothetical Chapter 7. So if the debtor can afford that, if that's financially feasible, that could be a good alternative. Chapter 13 has what's called the super discharge. I think it's not so super anymore, but it's still a super discharge, and it can discharge debts that would otherwise be non-dischargeable in Chapter 7. So a good example is non-support divorce debt. So child support is not dischargeable, but non-support divorce debt could be dischargeable in a 13 where it might not be in a 7. So that could be a good reason for a debtor to file Chapter 13 over Chapter 7. The other is the cram down. So if the debtor, for instance, has a car and it was purchased outside the 910 days, the debtor can cram down that car. That is, pay the value of that car as a secured claim. The balance of the debt would be treated as an unsecured claim. Certainly in a low dividend Chapter 13 plan, that can save the debtor a lot of money. It can also be other secured debt. I mean, before this state of high property values that we have now, we had a lot of debtors who were stripping second mortgages, where they had fully unsecured second mortgages. You could strip that in your Chapter 13 plan. That's very attractive. You can knock out $50,000 of a mortgage in a Chapter 13 case and make it unsecured. That certainly is a very attractive option. And then, of course, finally, probably the most common historically reason for people to file Chapter 13 is to cure and maintain a mortgage arrearage. Right? People are behind on their mortgage. They're either in foreclosure or in danger of going into foreclosure. Chapter 13 can stop that, and it can take the pre-petition arrearage, reorganize that in a Chapter 13 plan, and then resume their ongoing payments going forward. In some districts, some jurisdictions, the trustee is what's called a conduit trustee, where the entire mortgage is paid through the trustee's office. We don't generally do that here in the Northern District of Georgia. I mean, we have some one-off cases where that happens, but for the most part, it's debtors make the ongoing payments directly. The pre-petition arrearage is cured through the Chapter 13 plan. Some other considerations when deciding between Chapter 7 and Chapter 13 is the ability to get out if things go sideways. So if you file a Chapter 7 case, and in Carrie's example, Tamara discovers the debtor has the Van Gogh in the basement. The debtor can't just voluntarily dismiss that Chapter 7 case, right? The best they can maybe do is convert to 13, but otherwise, Tamara's going to get that Van Gogh and sell it for the benefit of creditors. Whereas in a Chapter 13 case, except in very, very, very small exceptions, the debtor has the absolute right to dismiss the case. Which, if you have client who, as Carrie did in her intake, you're still not quite sure about it, or there's some stuff that's maybe on the margin, maybe a Chapter 13 is the better bet, because if things go south, they can just get out.
Some wiggle room.
The next thing is time, right? Chapter 13 is a long-term project, both for you as the attorney and for the debtor. The Chapter 13 plan usually is anywhere from 3 to 5 years. And for a lot of debtors, that's a long time to maintain Chapter 13 plan payments. You have to make sure your client has the wherewithal, the financial wherewithal to be able to do that, to be able to sustain that. Debtors, a lot of them live kind of right on the margin, right, financially, and any hiccup, probably the same hiccup that brought them in the first place, could derail their Chapter 13 case. So it's important to keep that in mind. And then for you as the attorney, you're on the hook under our general order and local rules. Once you represent a debtor in a Chapter 13 case, you represent them till the end unless the court lets you out. So it's very, very important to keep that in mind going forward as well.
That actually applies in a 7 too. If you file a 7, you represent the debtor in everything until the court lets you out. Some people have failed to realize that to their detriment.
If we can go to the next slide, please.
That doesn't mean you won't be let out, but
Right, but you can't just let yourself out.
You can't let yourself out.
But of course, to file, if we go previous, one back, yeah. Of course, in order to file Chapter 13, the debtor has to be eligible to file Chapter 13. The requirements under Section 109E for Chapter 13 are a bit narrower than for a Chapter 7 case. First thing, the debtor must be an individual, right? A business entity, a trust, any non-human entity cannot file Chapter 13. It has to be a person. They have to have regular income. This doesn't necessarily have to be from a job or business. We tend to construe that quite liberally, but it has to be regular. It has to be something that they can depend on and that we can see will make this plan feasible going forward. There's also debt limits in Chapter 13. Currently, for non-contingent, liquidated, unsecured debts have to be less than $465,275, and secured debts less than $1,395,875. These numbers adjust periodically, kind of keep up with inflation and other issues. They're going up inflation and other issues. They're going up again April 1st of 2025. So again, make sure you check the debt limits, especially if you have a debtor who's kind of on the margins. We've started to see debtors with really high student loan debt who are pushing the unsecured debt limit or exceeding it. That's not uncommon these days. So doesn't mean necessarily that anybody's going to raise that issue, but it could be an issue, right? It could be an eligibility issue for Chapter 13. I think we can go to the next slide.
All right, next slide. All right, so the next thing to consider is the timing of the filing. I know in a whole lot of cases, you've got a client who's in there in an emergency, their house is about to get foreclosed, they're being garnished, some emergency means you've got to file now. But every now and then, someone comes in early enough that you can think about the timing of the filing. If current monthly income is based on a 6-month look back, if they got a big bonus or a big commission check, could you wait a month and that not be a factor, and then they're going to not have an issue with the means test? Or have they purchased a car recently? We all know about the 910-day issue, but there's also a 6-month issue. If you've got a client who's purchased a car in the last 6 months, go pull the title report and make sure that the lender perfected the lien on the car within 30 days of the purchase and outside of 90 days of the bankruptcy filing. I check title if you've purchased a car within 6 months, and roughly once a calendar, I find a car that isn't properly perfected. That often works out to the debtor's benefit, though. If the car is upside down, I'm going to let the debtor buy it for the actual value of the car, rather than the $60,000 that they owe on a $30,000 car. But it's something to look at. At $60,000 that they owe on a $30,000 car, but it's something to look at. Is there a tax claim that might be dischargeable if you waited a little while longer? That means you've got to look at the time, the date of the assessment, the date of the filing of the tax return. If they've got a huge amount of tax debt, it's worth trying to figure that out. And I say try, because it's hard to know whether a tax debt is dischargeable or not. Have they taken cash advances on credit cards or have they bought luxury goods? If they have, that's going to be non-dischargeable for 70 or 90 days from the filing. If they've moved to Georgia recently, are they still eligible for federal exemptions? If so, you might want to file sooner rather than later because the federal exemptions are a little bit more generous than we got here. And then transfers. Have they made any transfers? And this comes to Carrie's point about full disclosure. You can't help them with what they don't tell you, but if you explain that, things that they've done longer ago may not be an issue, but if you do it can be anywhere from 90 days to 10 years. So these are really important questions. If there's tax debt, the look-back period could be 10 years. And then the prior cases. Are they going to get an automatic stay? If you wait a little while longer, will they get one without having to file a motion that's going to annoy Judge Bonnefeldt? Or
It's not the motion that annoys.
it's a failure to do it properly.
Right.
So knowing about all of these issues and asking all of the right questions and then knowing what to do with the information that you get is really critical before the bankruptcy filing. All right.
And sometimes, I mean, it's you're going to have to weigh one against the other, right? It's which is in the client's best interest. Well, if we wait this long, we might be able to discharge these taxes, but at the same time, you might get foreclosed on, right? Or you might lose your car. So you have to, and make sure, understand that the debtor has to understand, well, if we wait this long, we might be able to discharge these taxes, but at the same time, you might get foreclosed on, right? Or you might lose your car. So you have to, and make sure, understand that the debtor has to understand the pros and cons, right?
Yeah,
of waiting
and Carol's point is really, really well taken. CYA.
Right.
You want to let your client
contract.
know this information and make the decision themselves, or put it in the contract, as Carrie says.
Make sure that they know that you have discussed it and they made the decision of which route they wanted to go on. And if you get that into your contract, then that will help you greatly if anything should arise.
You might not want to put it in the contract if it's attorney-client privileged information. Like, you might want to not want to say in the contract, I told you about the fraudulent transfer.
Definitely not on that one.
Maybe not that specific,
Decide
yeah.
on your tax limit versus your car.
But this is all really, go ahead, Angela.
Well, I was just going to relate,
Versus your car.
But this is all really, go ahead, Angela.
well, I was just going to relate an experience I had with a client. It was really great, and I did his price, everything was great. And I told him, hey, we may have an issue in your chapter 7 about this particular transfer. I think ultimately you'll prevail. There's not a guarantee, but I think there might be a fight about it with the trustee. And true enough, and just kind of as a matter of fact, at the signing of all his other papers, I went through a paragraph separate saying, I've been informed of this, I recognize this, and I still choose to go forward filing it. He signed it, I gave him a copy with everything else, and sure enough, we had a fight about that transfer. We ultimately did prevail, but it was really uncomfortable for him, right? It was nerve-wracking, all of those things. And he sat and expected that client to come at me like that. So you just never know.
Yeah.
Even if the client is going to acknowledge that you actually talked to them about it. So you might want to put it in writing somewhere and have them saying, yes, I still want to go forward.
And I would say that's especially important in corporate cases. I wonder sometimes why people file corporate Chapter 7s.
Yeah.
You don't get a discharge, and you're buying a trustee who gets to dig into your books and records. But the answer I get is that sometimes it stops the creditors, it's the nail in the coffin, so sometimes it does make sense. But it's also really important that your client understands someone might go digging and there might be things in there. And you might wind up having to pay money or having problems as a result. So the more you can disclose and discuss and put it in writing, I think the more you protect yourself too. And the last point is probably the most important for the actual lawyers in the room. Get a mentor. It is so important. It is so important, because Carol is passing out cards for NAPA. It's so important. You don't know what you don't know. At 30 years of practice, I'm still learning new things all the time. So as a baby lawyer, you can't be expected to know all of this, even no matter how proficient you are in the code. There are just practice things that you learn as you do. So if you can get someone who's willing to talk to you and work through these things with you, if you're not working with a firm, I think that's the best thing you can take from this presentation. All right, next slide.
So I kind of wanted to talk about some Chapter 13 resources too. Of course, in the Northern District of Georgia, there's 3 Chapter 13 trustees. There's my colleagues, Ms. Melissa Davey, Nancy Whaley, and myself. Melissa's office administers cases for Judges Bezier and Richie Craig in both the Atlanta and Union divisions. Nancy, Judges Sacca and Cavender in the Atlanta and Gainesville divisions. In my office, we handle cases in front of Chief Judge Ellis Monroe, Judge Sigler, and Judge Bonnefeld in Rome and Atlanta. All 3 of us are very cooperative, very willing to help. Please don't hesitate to reach out to us if you have questions, concerns about cases. It seems that things tend to work based on calendars. If something's coming up on a calendar, then we talk about it, but we can be more proactive than that. We can talk about cases ahead of time and just, shoot thoughts around. So don't hesitate to reach out to any of us. I also wanted to kind of bring up about debtor plan payments. I think there's some misunderstanding sometimes about how we accept plan payments and how they work in our offices. We both, all 3 of our offices, accept payments through employee reduction orders entered with the court, personal checks, money orders, certified funds, or electronic payments. And then with electronic payments, we offer 2 different options. All 3 of our offices do. Nancy and I both bank with Truist, so we offer, they're transitioning to a new improved website. It's going to have a more modern interface and also have the ability to do things that Truist ePay couldn't do until now, which was schedule payments up to 30 days out and also set up recurring payments. So it's a much better option on the Truist ePay. So I'd ask you, make sure you familiarize yourself with that and make sure your clients are aware of those changes. They're going to have to, your debtors have also been receiving notice. Any debtor that's been signed up for Truist ePay is receiving notices about this. They're going to have to register at the new site, so just make sure they understand that. Melissa's office uses a different bank, Fifth Third Bank, and they offer an ePay site as well. So if you have any questions about that, don't hesitate to reach out to her office. All 3 of us also use a third-party vendor called TFS Bill Pay, and I think there's sometimes some misconceptions with how that works. TFS Bill Pay offers different products. All 3 of us also use a third-party vendor called TFS Bill Pay, and I think there's sometimes some misconceptions with how that works. TFS Bill Pay offers different products. The usual ePay through TFS Bill Pay, this is where the debtor can start the payment today, and it'll post in our office in 5 business days. Now that delay, what that allows is it allows TFS to basically guarantee that payment. So once that payment posts in our office after that 5th business day, we know that's good funds. There's no holds on that fund, on those funds. Whereas with the ePay through the banks, the payment will post the day after, the next business day after the debtor makes it, but it's like a personal check. It can bounce if there's non-sufficient funds in the account at that point. So it's important to recognize those differences. TFS also offers other versatile products, including they can let the debtor make recurring payments. The debtor can sign up. Other versatile products, including they can let the debtor make recurring payments. The debtor can sign up for reminders. There's also a product they offer called eWage, which the debtor can take to their employer. And to their employer, it looks like just a direct deposit, but it's actually going to TFS Bill Pay and coming to our office. So it's kind of a sneaky EDO where the employer doesn't have to know the debtor's in bankruptcy, but it functions like an EDO. And there's also MoneyGram, which is quick. It's where the debtor can go to, say, Walmart or any store like that which offers MoneyGram and pay with cash, and that payment will post quicker. I will say it's very expensive. I don't think most debtors need to use that. There's really not going to be many reasons why a debtor would need to use that, but it's an option that's out there. And also, TFS will process employer payments. You might have noticed the in the employer deduction order in our district, specifically tell employers that they are allowed to make electronic payments to our offices. We get those through ADP as well. So any employer that uses ADP for payroll processing or paychecks, those might be coming to us electronically. And of course, anything we can move to electronic payments these days is probably better given the way the mail works or doesn't work, and just the problems that we have with checks. So, but TFS also sometimes for smaller employers can provide a good method of letting employers process employer deduction orders. All three of us will also take walk-in payments. I would strongly discourage walk-in payments. There's really no need for a debtor to come downtown, fight for parking, come to our offices to drop a payment on our Dropbox. None of us take payments over the counter. It all goes into a Dropbox. They'll be processed just like any other payments, so it doesn't really speed things up or anything, and it's just more of a hassle. Also, at least Nancy's office and my office have security issues. You cannot just come up to our offices. You have to go through security in our buildings, and it's just a hassle, and there's really nothing gained from it. So I would encourage you to encourage your clients not to come to our offices directly, but we do offer drop boxes if they intend to.
And if everybody can know, the reason we do that, and we handle all money with dual control.
Yeah.
That means 2 people, cameras, always on the money so that we can protect it, protect ourselves, protect our employees from theft. And so it's all about safety.
Exactly.
And so that's why. It's not that we don't want to interact with your clients or anything like that. Though, I will say, in the world we live in now, I mean, my suite is locked, and I want it locked. I want my floor locked. I mean, there was a shooting, and I'm in Peachtree Center. There was a shooting there not long ago. And
that's part of the reason why our floor is locked down as well. It's just we've had people come up to the floor that shouldn't have been there, and other issues like that. And like Melissa says, it is all about dual control. We have 2 people go to that Dropbox to recover that money, and it's always under dual control, always under camera surveillance. So that's why.
And that permits the courts, the judges, when the debtor says, well, I made my payment, and the trustee lost it, to say with some degree of confidence that's not likely.
It's not to say we don't make mistakes. I mean, mistakes can happen. I will say that. If you have a client,
But you don't lose the
we don't lose money. We don't lose money. We don't lose money. We might post it to the wrong case, or something like that may happen. It's important that any payment that your client makes has, identifying information on it. I mean, we do get money orders with nothing on them.
we get cash sometimes.
We get cash. We don't want cash. We don't take cash, but it sometimes shows up. But it's important that at least a case number be on the money order or on the check or money order so that we can. It sometimes shows up. But it's important that at least a case number be on the money order or on the check or money order so that we can make sure it posted to the correct case. If not, it goes into a suspense, and then we wait for somebody to come claim it if we can't identify it.
Oh, I lost $1,000 last week. If it matches up, it was me.
Well, give me the money order number and I'll look
The
for it.
serial number of the bills.
Yeah.
And proof of withdrawal.
I'd also, of course, you probably know that all 3 of our offices, we use a secure document portal through a vendor called Bankruptcy Documents. That's our preferred method of getting anything uploaded to our office. We don't want emails, it's just for security purposes. The document portal internally in our offices routes it to where it needs to go so things get processed faster. So we really encourage the use of the document portal. And I would encourage you also to look at the National Data Center. This is ndc.org, that you might want to look into, give you reports and kind of show you the progress of all of your cases. And it's something, it's quite valuable, and it's free for debtors and debtors' attorneys. It's paid for by creditors. So something to look at. Go to the next slide.
Yeah. Before you go on, one of the things that, about your clients mailing money, please encourage your clients to do e-pay. We are all 3 having terrible times with mail, and many of you all have been victims of bad mail. So if you are not signed up to receive your attorney checks through electronic direct deposit, please see any one of us and sign up so that you can have your monthly payments and your payments throughout the month directly deposited into your account. It's way more efficient. You're not gonna get a lost check, positive you're not already, if you're debtor's counsel. If you represent creditors, please encourage your clients to be willing to sign up to have all of their payments made electronically. That helps everybody as well. And then I think I'll put in a pitch for Maria. MacBag is going to be doing a program here shortly on NDC. So if you do not use the National Data Center, either from a creditor side or the debtor side, please look for that. And it's a great presentation. You can learn all about the National Data Center and what they can do for you and your clients.
Quick question, Ed. Have y'all considered an ability for the debtor's lawyer to be able to make a payment to y'all's office through electronic transfer? Is that?
You can do that through TFS.
Yeah, you can do that.
As the attorney?
Yeah.
Not on behalf of the debtor?
You can.
Okay.
And that's
You
a
mean
great.
for your client.
Yeah. So the client comes in, brings us cash, we reckon receipt. And we
You
want
can
to-
do that through TFS.
Yeah, exactly.
Money to y'all. Okay.
Yeah. I don't think you can do it through ePay because it's
And that's
you
a
mean for
great.
your client.
Yeah.
So the client comes in, brings us cash, we reckon receipt. And we
You can
want to-
do that through TFS.
Yeah, exactly.
Money to y'all. Okay.
Yeah. I don't think you can do it through ePay because Truist is
But TFS
regulated through the banking
TFS.
requirements, but TFS you can.
And those are great points on the attorney fee EFT payments. As Nancy said, I would strongly encourage you to sign up for that. It is just better all around. And the vouchers for those are on NDC, so you want to make sure you're on NDC to get the voucher for those electronic payments on your attorney's fees. So then turning to appearing virtually. So this may be going away to a large degree, but it's important to remember that a virtual hearing it's a court hearing, right? You are appearing in court. You must observe the same formalities as you would if you were physically in the courtroom. So, of course, dress appropriately, wear appropriate conservative business attire, waist up at least, right? Or at least what's on camera. Use a professional background, or at least not a distracting background. I think that's really important. A plain background is probably the best, just to keep things simple. You minimize distractions and disruptions. So, the example we have is your cat jumping on your desk. Maybe you walk the cat out of the room during the hearing. But also, of course, make sure your connection is stable. I see this sometimes a lot with debtors at 341s. They just have a poor internet connection, and their internet connection is not strong enough to sustain the Zoom call. And but that can apply to you as well. Our rule for my staff attorneys working at home is if at all possible, you plug into your router. Don't just rely on Wi-Fi, because unless you have really good Wi-Fi, sometimes the bandwidth just isn't there to sustain a connection, an internet connection that can sustain Zoom, and if you're logged into something else as well.
Ed, can I ask you a question on that?
Yeah. And if you're logged into something else as well.
Ed, can I ask you a question on that?
Yeah.
Do you require the debtors or the parties that you're representing that are going to be appearing virtually? Do you inquire about them, about the quality of their Wi-Fi coverage, about the quality of their devices? Do you do a test run with them before they actually take a hearing?
As a trustee, I don't know,
Okay.
but I would encourage maybe the debtors' attorneys to do
As
that.
debtor's attorney, we do.
Okay.
We have a whole little package that we go over with them depending on what phone they have, depending on what computer they're gonna use, where is the Zoom button, where is the video button, where is the mute button. All of that is in a little presentation that we do with them to determine how they're gonna be able to work it and if they can work it. And then that helps us make the determination as to whether or not we wanna bring them into our office for the hearing. Whether or not they're gonna be able to have some internet issues that would cause the hearing.
Stable enough internet connection. Consider a headset. If that, if there's ambient noise or other issues, it might be nice to wear a headset. Yeah, we got a question in the back.
I know Judge Ellis said you were going to go back to in-person court. Are we going back to in-person 341 meetings as well?
No, that's staying on Zoom. That's staying on Zoom.
So those are under the United States Trustees Program, which is part of the Department of Justice, which is part of the executive branch government, so.
But it's worth mentioning that the 341 is a court proceeding.
Right.
both the attorneys and the debtors should be dressed appropriately. They should not, for instance, be sitting on the toilet when I call them, which has occurred. I wish I could say I was joking. I mean, she did flush and then leave the restroom for the rest of the meeting, but but the attorneys too should be dressed appropriately. I've had attorneys appear in crew neck t-shirts, so it's important that they see this as real as well. And if we've got a bunch of attorneys having conversation before I call the meeting to order, or if we've got people dressed inappropriately, it doesn't add the gravitas that we really need to have for something that is really so very important. So I would add, I'm sure you already tell your clients all of this, but it's very important. They don't have to come down here anymore, but they can't get annoyed with me if they've had to wait 10 minutes for their meeting. If this doesn't continue to work well, then they will have to look at bringing us back in person, and none of us want that.
Hammering that home in the consultation is part of your job. Make sure that they understand that it is a federal hearing. You are appearing in a matter where you're going to be under oath, and you need to treat it with that amount of respect. So make sure that they understand that that's what they're doing. A lot of them can't get out of work, and you know that they're going to be sitting in their car. So make sure that they understand that that's what they're doing. A lot of them can't get out of work, and you know that they're going to be sitting in their car, and they say, "Can we sit in our car?" Yes, you can sit in your car, but please don't let your car be moving. Please be parked on the side of the road.
Right, we will not
conduct it if they're moving.
Exactly. We will not conduct the meeting if they're driving. But I understand for a lot of debtors, as Carrie said, they're at work, they take a break, they go out to their car for privacy and do their meeting. That's fine. As long as they're not doing this with their phone, put your phone down, sit, look at me, answer the questions, we're good. It doesn't have. Something about dragging everybody down here to the courthouse, making them go through security, coming up to the third floor where we all used to hang out all day and have the big signs that says FBI investigates bankruptcy crimes. I think that did have an impact on a lot of debtors, right? It did kind of hit home that this is serious. This is the real deal. That professional, dignified environment as much as possible in the Zoom 341s. And to answer the question again, the U.S. Trustee's Office has decided that consumer debtor 341s, 7 and 13s are going to be virtual, going to be on Zoom, and that is going forward. That is the rule. There's no talk of changing that at this time.
It's just
And do you want to talk about the UST videos?
Yes, I was going to bring that up. Thank you, Nancy. That the United States Trustee has a new webpage up on their website. We have links to it from our websites as well. It has some really good information about Zoom 341s. It has some sample videos of how a 341 might go, best practices, acceptable ID documents, things like that. It might be good to send your clients there to go look at that just to see what a 341 is going to look like and how it might work.
Right, then the next topic then, unless we've got more to say on that,
Can I say one more thing? One more thing. There's going to be a portal rolled out soon, and it will be linked on all of our websites. This is just for meeting a creditor, so I'm sorry, it's not about court hearings, which will be in person anyway. But for Zoom 341 hearings, there will be a portal where you can have your client, and you can go and you will click on it, and then it will allow your client to put their name in there before they join Zoom. You do not have to download the Zoom app anymore. It'll be mobile friendly. You can do it. You can put your cases in. It's gonna. It will really streamline the process for connecting. They're not required to use that, but the U.S. Trustee is approving it and working with the National Association of Chapter 13 Trustees on doing it. Yeah, it is piloting now
in some other jurisdictions, and hopefully coming here soon. So that will make it a lot easier because then you won't have to.
It's probably like 6 or 7 months away.
Yeah, it's a while. It's sometime out, but it's.
They can test their video, their audio. They can put their
coming here soon. So that will make it a lot easier because then you won't have to.
It's probably like 6 or 7 months away.
Yeah, it's a while. It's sometime out, but it's.
They can test their video, their audio. They can put their name in before they join.
Right, and they don't have to download the Zoom app. They can do it all through this webpage. Yeah. So it will be. It'll be good when that comes, but like Nancy said, I think we still have some time before that arrives here. Finally, I wanted to just, of course, remind everybody that the recordings of both court, virtual court, and the 341s are audio only. So it's important that your clients understand that they can't just nod their heads or say, They have to answer the questions clearly so that it appears on the recording, because it's audio only, both for court and for the 341 meetings.
Then, since we're all going to be going back to the courtroom very soon, we thought we'd talk about that. There are some people who haven't been in the courtroom ever, and they've been attorneys for that perhaps they don't. On the list is no food or drink. Judges, tell me if I'm wrong, but I think a water bottle that's sealed is okay, especially if you've got a long hearing. Turn off your cell phone. Don't just put it on vibrate. Completely off is the best practice. If you've ever been in the courtroom when an attorney's phone goes off and they're standing at the podium, it's mortifying. Just don't put yourself in that situation. Which side do you sit on? That's something that you don't know if you've never been there. So in bankruptcy court, the Chapter 13 trustee sits on the right, or the movement sits on the right, and the defendant or the other party sits on, or the respondent sits on the left-hand side as you're facing the judge. If more than one matter is being heard, like in a 13 calendar, like we had in this morning, the 13 trustee is going to stay at their table on the right, and as your case is called, you can go to the table on the left. Your client, if they're in the courtroom, should come and sit with you as well. And then when your matter is over, you can begin your presentation. You actually need to speak into the microphone, preferably at the podium. But if you're at your table, you've got to make an objection or answer a question or something like that. That's okay to do from your table, but into the microphone, because as Ed said, these are being recorded, just the audio. And even if the judge and everyone else in the courtroom can hear you, if it's not picked up on the microphone, you're not going to be on the recording. This is a big one that I've noticed in hearings attorneys aren't doing is mark your exhibits. Give them to the opposing party. Be ready to go when you get there. And if you're presenting these exhibits, ask permission before you approach the bench or the witness. It's basic decorum that I think probably everybody in this room knows, but the new attorneys are just learning this because they haven't had to be here yet. Okay, next slide.
A little bit more for our new back in person. Make sure that you are in the courtroom early.
Okay, next slide.
A little bit more for our new back in person. Make sure that you are in the courtroom early. Being there early helps you get a lot of stuff done prior to your hearing, and getting there early is going to make your life a lot easier. If you file a motion, if it's your motion, you have to appear and make the announcement. You can't assume that just because you've already spoken with the trustee prior and you know that it's a consent order, you can't assume that the trustee is going to make that announcement for you. A lot of times they do, but a lot of times they don't. So make sure that you know how your courtroom works. When we're back and we're going to be appearing in multiple courtrooms, we all are going to have it. We all did it before, but the new guys may not know. There's courtrooms going on, 3 or 4 courtrooms on a day. Courtroom and the clerks that are working the calendars, you can make your announcements in advance. Having relationships with your trustee, they can sometimes make announcements for you, but it's just very important that you communicate that ahead of time so that no one is looking for you. If you're not in the courtroom and you don't make that announcement, that can hold up the whole calendar, and the clerks definitely do not like that. If you are not going to be able to appear, or you have the matter worked out, you can always contact the clerk in advance. Most of the clerks will take announcements prior to the hearing, but most of them want that at least 24 hours in advance. And most of those can be done by email. Be sensitive to ex parte communications in that situation. You want to make sure that you're including everyone, all parties, to those announcements that you're calling in. And then finally, when your matter is concluded, this usually means when you have been actually presenting the matter, not necessarily on a calendar call, but if you've been presenting the matter and you're finished, make sure that you ask to be excused. Otherwise, do not leave the courtroom. Next slide.
Be prepared. I mean, this is probably the best thing you can do. I would say assume that any matter you have is going to be heard by the court and be prepared to address the court about it. Even if you've worked out a consent order with the opposing party, with the trustee, or you've decided you're going to reset your motion, be ready to be heard, because the court may decide that the court wants to hear that matter, even in the absence of opposition. It's important to know what the judge may want to know about that. One good way to figure this out is to observe. What we've talked about a lot in our bar recently about lamenting the virtual court. It's important to know what the judge may want to know about that. One good way to figure this out is to observe. What we've talked about a lot in our bar recently about lamenting the virtual courtroom is the fact that you don't get to see other people practicing. How many of us learned was to sit in the courtroom and watch other people present cases to the court. You kind of see, you kind of learn about the judge, you learn about what the judge is interested in, what they're going to ask, the kind of questions they're going to ask, and you figure that and get a sense of that, and you know to be prepared to answer those questions. Expect the unexpected, right? Even just know that the court may want to hear it, or you could have a creditor that comes out of the woodwork and opposes confirmation or opposes your motion, whatever relief you're seeking, that you didn't expect. So be ready to present that. Know the facts. Make sure you've talked to your client about this. And this sometimes can be an issue if you have a larger private client. But make sure, at the outset, but make sure you have the relevant facts to proceed with that motion. Mostly on a mass calendar, our courts are not going to take evidence, but they're going to want to hear a proffer. They're going to want you to be able to proffer what you would show, or what you would present as evidence in that matter. You need to have those facts together and know what, and anticipate what kind of questions the court may have based on that and be able to answer those questions. Know who has the burden of proof and what the elements are for the relief that you're seeking. Perfect example would be, for instance, Chapter 13 hardship discharge. That's under Section 1328B. There's three basic elements, right? It's the circumstances that are leading to this are beyond the debtor's control. They've met the liquidation test, that is, they paid into their unsecured creditors what they would have gotten under Chapter 7, and that modification is not practical. Those are the three elements. You need to be ready to address those if the court marks that ready and wants to hear it. Chapter 7, and that modification is not practical. Those are the three elements. You need to be ready to address those if the court marks that ready and wants to hear it. Be able to address what those three elements and how the facts in your case meet those elements. So it's very important that you have that information and be ready to go should you have to present that to the court.
I'm on. We're out of time, I think.
Yeah, there.
Let's never stop. Well, one of my pet
There's one more slide, let it finish.
I'll be brief.
With 82 subparts.
Yeah.
A good lawyer knows the law. A great lawyer knows the judge. Okay? And it's just so that you can tailor your presentation to be what the judge is interested in and will be receptive to. Now, you would think, and after 23 years I've been doing this almost, maybe more, there are some lawyers, I think, who know what I'm going to do before I do. But there's one thing that I ask on every stay relief motion. Several things. Here's what I want to know. The value of the property, the payoff, the amount of the arrearage, and when the last payment was made. Among other things, I need to know the value of the property and the payoff in order to determine whether there's equity in the property. Say, just a moment, Connor. I'll have to check. And you've been sitting there waiting for your case to be heard, and you know your case is going to be heard. That would be a good time to check this. I may be singing to the choir here, but that's the, and I have decided that I will be my passive aggressive self, and I will just sit there while that lawyer fumbles through the papers and not make a big deal about it, and not be sarcastic and say, it might have been nice if you looked at that and thought about getting that information before your case was called. And I won't say it, but I will be thinking. Well, addressing the court, be nice, polite. It says don't argue with the court, but argue to the court. It's okay to argue with me, I enjoy it. It's okay to argue with me, I enjoy it. Lay out the facts in a logical order. Tell the story. And in Neil Batson's words again, be the trusted guide to your case. You want to be the person that the court knows is going to give a straight story and will be the trusted guide to the case. Don't refer to the other side by their first name. This used to be not much of a problem. It does become a problem when we're on Zoom, but it's Mr. or Ms. or whatever. It's just a matter of respect for the formality of the courtroom. Closing thoughts. Next slide. Do good and avoid evil. That's what that says. Thank y'all. And the last one, you can raise your things again. Find a mentor. And I would say that, lawyers are people who want to help people. And bankruptcy lawyers especially are people who want to help people. And we are a community. We have to get along with each other because we see each other all the time. And I think bankruptcy lawyers in general are always willing to be a mentor. So if you've got a problem, you've got an issue, call somebody. Find somebody that will talk to you, and generally they'll be happy to do it because you might refer a case to them when you have one.
One more plug for SBLI.
Oh, yeah.
If you have not yet registered, we have some coupons today that will give you if you register today. It's going to be March the 19th through the 21st at the Whitley as usual. So hopefully we see everyone there. Thank you.